Let us start today's class with Chapter 2, the Indian Contract Act. Unit 1, Nature of Contract. So, basically here's the unit overview. Elements of contract, essentials of a valid contract, types of contract, agreement, enforceability. Agreement is offer and acceptance. Offer is legal rules of valid offer, kinds of offer, essentials of a proposal, communication of offer, acceptance, legal rules and for valid acceptance, communication of acceptance. So, to understand law before Indian Contract Act. Now, these are some of the things like Arabic word aqd means contract, which means conjunction, then ijab means proposal, kabul means acceptance, express consent. Then we have Hindu law, basically minor, intoxicated person, old man, handicapped cannot enter into a contract, infant from age 8 years to 16 years is considered as boyhood, and after 16 years the person is competent to enter into a contract. During British period, during the advent of the Indian Contract Act, the English law was applied to the presidency towns of Madras, Bombay and Calcutta under the Charter of 1726 issued by King George to the East India Company. If one of the parties to contract is from either of the religion and other is from other religion, then the law of the defendant is to be used. This was followed in the presidency town, but in the cities used the presidency towns, the later. Okay. Now the law of courts introduction. The law of contract constitutes the most important breach of mercantile or commercial law. It affects everybody, more so trade, commerce and industry. It may be said that the contract is the foundation of the civilized world. The law relating to contract is governed by the Indian Contract Act 1872. It was formed on April 25th, 1872 and came into force on September 1, 1872. The preamble of the act says it is an act to define and amend certain parts of the law. Okay, Article 370 of the Indian Constitution, Jammu and Kashmir state. Then we have two parts. First part, Section 175 deals with the general principle of law of contract. Therefore, applies to all contract irrespective of its nature. Second is parts 124 to 238 deals with certain specific kinds of contract, indemnity, guarantee, bail, maintenance, etc. Contract is more usual method of defining the rights. Okay, all these things are basic. Now, when an agreement is voidable and enforceable by one party, an agreement is void and not enforceable at all. Okay, now what is contract? So I hope that introduction is quite clear. Now, what is contract? According to Section 2H of Indian Contract Act 1872, an agreement enforceable by law simple. It consists of two things, an agreement and enforceability by law. Agreement, the term agreement is given in Section 2 Clause E of the Act is defined as every promise and every set of promises forming the consideration for each other. 2B, promise, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Proposal when accepted becomes a promise. Okay, now agreement, offer or proposal plus acceptance is consideration. Now enforceability by law means it must give rise to a legal obligation, which means a duly enforceable by law. So contract is equal to agreement plus enforceability by law. Now over here some examples are given. Differences between agreement and contract. So meaning every promise and every set of promises forming the consideration for each other. Contract, agreement enforceable by law. Agreement plus legal enforceability over here. Promise plus consideration. So M. Meaning. Scope S. Wide term including both legal and social agreement is a narrow sense with a specification contract only legally enforceable agreement S. L. Legal obligation. It may not create legal obligation. An agreement does not always grant rights to the parties. Necessarily creates a legal obligation. A contract always grants certain rights to the party, every party. Okay, nature N. All agreements are not contracts, but all contracts are agreements. So MSLN, meaning, scope, legal obligation, nature. Agreement versus contract, MSLN, meaning, scope, legal obligation and nature. So we can say that every agreement is not a contract. Okay, every agreement is not a contract, but all contracts are agreement. Essentials of a valid contract. Over here, now Section 10. According to Section 10 of the Indian Contract Act 1872, an agreement is a contract. Every agreement is a contract if it is made by the free consent of the parties, okay, for a lawful consideration, okay, and with a legal object, for a lawful object, and are not expressly declared to be what. We will be coming to it. Let's see. It is given in Section 10. Okay, agreement, free consent, competency of the parties, legal consideration, then lawful, legal object, lawful consideration, legal object, not expressly declared to be void as per Section 24 to 30 and 56. Okay, while the other one not given in Section 10 but are also considered essential. Two parties, intention to create legal relationship, then fulfillments of legal formalities, certainty of meaning, possibility of performance. So we can say basically that in to remember this, we have FCLLD, that is AFCLLD. We have AFCLLD. A, that is agreement. F, that is free consent. Then C, that is competency to the parties. Then again L, that is lawful consideration. L, that is legal object. And D, not expressly declared to be void. AFCLLD. Over here it is TL, TIL, CP. That is two parties. I, that is intention to create legal relationship. Then L, legal formalities, fulfillment of legal formalities. Then C, certainty of meaning. And P, possibility of performance. So basically that is TIL, CP. TIL and then CP. That is it. Over here is the terms of section 10 of the Act. All agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared to be void. Section 10. All agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared to be void. So, to create a valid contract, the following elements should be present. That is TILCP, the ones which are lawful object are not expressly declared to be void. Okay. Since section 10 is not complete and exhaustive, there are other sections which also contain. So this one is this one. That is not given in the section of 10. That is TILCP. Let us see it one by one. So two parties. One cannot contract with himself. A contract involves at least two parties. A contract involves at least two parties, one party making the offer and the other party accepting it. A contract may be made by natural persons and by other persons having legal existence, that is companies, universities, etc. It is necessary to remember that identity of the parties be ascertainable. Okay. Now State of Gujarat versus Ramannal S and Company. So in this basically case क्या हुआ कि ये जो एक partnership firm था जो कि dissolve हो रहा था and in that dissolution के टाइम पे द सेल्स टैक्स ऑफिसर वांटेड टू टैक्स द ट्रांजैक्शन जब जो एसेट ऑफ द फर्म वर डिवाइडेड अमंग द पार्टनर्स. तो ये ऐसा नहीं हो सकता है क्योंकि जो एक पार्टनरशिप होता है, जो पार्टनर होता है वो जॉइंट ओनर होता है, इसीलिए दे कैन नॉट बी टैक्स्ड फॉर दैट. ओके. सो स्टेट ऑफ गुजरात वर्सेस रमन्नाल एस एंड कंपनी. Parties must intend to create legal obligation. There must be an intention on the part of the parties to create legal relationship between them. Social or domestic type of agreement are not enforceable in court of law and hence they do not result into contract. Balfour versus Balfour. Balfour versus Balfour के केस में क्या होता है कि a husband agreed to pay his wife a certain amount of as a maintenance. Now he failed to pay as promised. Okay. Now what happened? That wife sued him, but without any agreement, without any proper legal agreement, there is nothing written. Okay. So it's a social agreement. So the courts held that they are not liable to fine each other. So this was a domestic agreement. So parties must intend to create a legal relationship. Now we have another point, that is other formalities to be complied with in certain cases or other legal formalities. Okay. A contract may be written or spoken as the legal effects. There is no difference between a written contract and contract word of mouth, but in the interest of the parties the contract must be written. Now it can be written or oral, but it is advisable to be written. Same is in the case of partnership deed. It can be anything. It can be written or oral, but it is advisable to be written. If you want to sue someone, that is better to be written. Okay. In case of certain contracts, some other formalities have to be complied with to make an agreement legally enforceable. For example, contract of insurance is not valid except as a written contract. Further, in case of certain contracts, registration of contract under the laws which is in force at the time is essential for it to be valid. That is in case of immovable property. Thus, where there is any statutory requirement that any contract is to be made in writing or in the presence of witness, or any law relating to the registration of documents must be complied with. Certainty of meaning. The agreement must be certain and not vague or indefinite. Okay. Possibility of performance of an agreement. The terms of an agreement should be capable of performance. An agreement due to impossible act in itself cannot be enforced. Like you discover treasure by magic. That is basically impossible. Okay. So basically, two parties, intention to create legal obligation, then other legal formalities to be complied with, then certainty of meaning, and then possibility of performance of an agreement. Let us move forward to the one which is present in the section 10, that is AFCCLV. Okay, so A is agreement, F is free consent, C is competent to contract, capacity of the parties basically, and then we have consideration. Okay, consideration. Then we have lawful consideration and object, section 23, and not expressly declared to be void. So, offer and acceptance or an agreement. An agreement is the first essential element of a valid contract according to section 2E, which is known as every promise and every set of promises. And 2B, what is proposal? What is proposal? Okay, proposal is defined. Proposal is what? Acceptance. Okay, so what is acceptance or proposal? When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. The proposal, when accepted, becomes a promise. Okay. Free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. Consensus ad idem. Okay. It should not be caused by coercion, undue influence, fraud, misrepresentation, or mistake. Okay. Nice. So, capacity of the parties. Capacity to contract means the legal ability of a person to enter into a valid contract according to section 11 of the Indian Contract Act specifies that every person is competent to contract. Who? MSD. That is, who is major, who is of the age of majority according to the law to which he is subject, is of sound mind, and is not otherwise disqualified from contracting by any law to which he is subject. So MSD, that is majority, he should be a major, he should be of sound mind, is not disqualified from contracting by any law to which he is subject. Okay, now qualification A is given, B is given, and then C. So first of all, major, you must be of 18 years of age and then more than that. Okay, then B, that is a lunatic, idiot, drunken person or under the influence of some intoxicant, is not of sound mind. Okay, now qualification C is given as alien, enemy, foreign sovereigns or convicts, they are disqualified, okay, by law. So these are not valid, like void. Okay, consideration. What is the basic section 2D? Okay, consideration. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such an act or abstinence or promise is called consideration for the promise. Okay, quid pro quo means something in return, a valuable consideration in law. It could be for any property, forbearance, detriment, loss or responsibility given, suffered or undertaken by the other. Okay, now over here section 23, lawful consideration and object. The consideration object of an agreement must be lawful. Section 23 states that consideration or object is not lawful if it is prohibited by law, or it is such as would defeat the provision of law, if it is fraudulent or involves injury to the person or property of another, or court regards it as immoral or opposed to public policy. Nice. Not expressly declared to be void. The agreement entered into must not be which the law declares to be either illegal or void. An illegal agreement is an agreement expressly or impliedly prohibited by law. A void agreement is one without legal effects. Types of contracts we have VFP. On the basis of validity or enforceability, formation and performance. Validity, V3IU, that is valid contract, a void contract, a voidable contract, unenforceable contract, and illegal agreements or illegal contracts. Simple. Formation, we have E2IQ, that is express contract, quasi contract, implied contract, e-contract. Okay, now when I say quasi contract, you just remember that finder of lost goods comes under the quasi contract. Okay, performance executed. Contract means it is done in the past. Executory contract means in the future it has to be done. Unilateral contract means one party has to perform it because one party is done. Bilateral contract means both the parties are there to perform. Simple. Then on the basis of this one, valid contract, an agreement which is binding and enforceable is a valid contract. It contains all essential elements of a valid contract. Void contract, section 2J states that a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Thus a void contract is one which cannot be enforced by a court of law. Okay, it may be added by way of clarification that here a contract is void. It is not a contract at all, but for the purpose of identifying it, it can be called a void contract, voidable contract. 2I, an agreement which is enforceable at the option. An agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of other or others, is a voidable contract. Thus, in fact, where one party is of the agreement to this position is legally entitled to authorized to avoid performing this part, then the agreement is treated and becomes voidable. Now, following situation when a contract is voidable: when consent of party is not free, like coercion, undue influence, then misrepresentation of fraud. Now, remember it with the trick CPT, consent is not free. Then P, prevents him from performing his, like prevention of performance. First is consent not free. P, performance of prevention of performance. And T, failure to perform on time, when time was essential. Okay, specified time. Okay, now distinction between void contract and voidable contract we have given. So it is MECPR, meaning enforceability cause, then performance of contract and rights. So void contract 2J and voidable contract 2I. Okay, so meaning void contract. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Voidable contract, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. Enforceability, a void contract cannot be enforced at all. Voidable contract, it is enforceable only at the option of the aggrieved party and not at the option of other party. Cause void contract, a contract becomes void due to the change in law or change in circumstances beyond the contemplation of the parties. Voidable contract, a contract becomes a voidable contract if the consent of the party was not free. Now, P, performance of contract. A void contract cannot be performed, but voidable contract, if aggrieved party does not within reasonable time exercise his right to avoid the contract, any party can sue the other party for claiming the performance of the contract rights. A void contract does not grant any legal remedy of any party to any party. A party to whose consent was not free with the right of the resigner has got the right to resign the contract within the reasonable time. It also rescinded. If so rescinded, it becomes void contract. It cannot be rescinded. It is a valid contract. Illegal contract, law forbids to be made. The court will not enforce such a contract, but also the connected contracts. All illegal agreements are void, but all void agreements are necessarily not illegal. So these are both, like, despite there is similarity between them, because both in the cases they are void ab initio and cannot be enforced by law. So 2G, that is an agreement not enforceable by law, is void. Okay, so that is void agreement. Consideration of the contract, illegality of the contract. Now, void agreement versus illegal agreement over here, that is SNPC, scope, nature, punishment and collateral agreement. Scope, void agreement is not necessarily illegal. Illegal agreement is always void. A void agreement is not necessarily illegal. An illegal agreement is always void. So basically what? All illegal agreements are void, but all void agreements are not necessarily illegal. Nature, not forbidden under law, are forbidden under law. Illegal agreement. Punishment, parties are not liable for any punishment under the law. Illegal agreement, parties to illegal agreements are liable for punishment. Collateral agreement, void agreement, it is not necessary that agreements collateral to void agreements may also be void. It may be valid also, but illegal agreements collateral to illegal agreements are always void. Unenforceable contract means जिसको contract को enforce नहीं करना था, किया जा सकता था. Okay, so like unenforceable contract, like if a contract was to be enforced, okay, but due to some technical defect, it was good in substance, but because of some technical defect, that is absence in writing, barred by limitation, one or both parties cannot sue upon it, is described as unenforceable contract. Okay, similarly, an agreement to transfer immovable property should be written under being enforceable. Now we have express contract by words, writing, section 9. Okay, implied contract is like come into existence by implication. You imply it by section 9. Okay, nice. Tacit contracts means silent contract. This is a type of implied contracts. Okay, means silent. Those words are spoken or written without any spoken or written when cash is withdrawn by ATM. That is what tacit contract. Quasi contract. Now here, finder of lost goods you will write. Okay, then paid under mistake. Okay, then delivery of goods by mistake, that is quasi contract. Okay, e-contract means emails, that is EDI, that is electronic data interchange. On the basis of performance, executed means it is done. Okay, it could be an act of forbearance. Executory means in future only. Okay, it is unilateral and bilateral. Unilateral means one-sided contract. Bilateral means both parties includes. Now section 2A, proposal or offer. Okay, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Okay, now essentials of a proposal or offer over here. So that is PEWP, that is the person making the proposal or offer is called the promisor or offerer. For a valid offer, the party making it must express his willingness to do or not to do something. Okay, then willingness must be expressed with a view to obtain the assent of the other party to whom the offer is made. An offer can be positive as well as negative. Now kinds of offer, how made, it is express offer, implied offer, to whom made, general offer, specific offer. Now over here, general offer, specific offer, standing offer, cross offer and counter offer. Over here you can write GSSCC. So basically general offer generally सबके लिए open रहता है. Okay, स्पेशल ऑफर स्पेसिफिक पर्सन के लिए ओपन रहता है. जनरल ऑफर में आप लोग याद कर सकते हो कार्लिल वर्सेस कार्बोलिक स्मोक बॉल कंपनी. स्पेशल ऑफर में आप लोग याद कर सकते हो बोल्टन वर्सेस जॉन्स. ओके, ये स्पेशल पर्सन के लिए रहता है. काउंटर ऑफर रहता है कि जैसे काउंटर ऑफर किया जाता है ना, किसी को ऑफर किया गया लेकिन उसमें कुछ मॉडिफिकेशन या वेरिएशन, कुछ ऑल्टरेशन करके वो दोबारा काउंटर कर दिया, दैट इज काउंटर ऑफर. बेसिकली क्रॉस ऑफर किया जाता है ना कि दो पार्टी जब सामने से ऑफर करते हैं, लाइक ए कहता है कि मुझे अपना कार बेचना है और बी कहता है मुझे आपका कार खरीदना है, विदाउट इवन नोइंग, विदाउट इवन रियलाइजिंग कि वो भी ये बात बोलेंगे, तो दैट इज क्रॉस ऑफर. तो क्रॉस ऑफर में बेसिकली व्हाट, क्रॉस ऑफर में इट इज सेड दैट इट इज रिटन ओवर हियर, लाइक यू कैन से over here you will see it is written that it must be written somewhere. Yeah, over here you can say general offer made to public at large, anyone can accept it. Acceptance can be done by performance of the act, like Carlyle versus Carbolic smoke ball. Special offer में Bolton versus Jones है, specific और a certain person के लिए acceptance must come from the specified person. Okay, counter offer rejection of original offer हो जाता है, ठीक है, कोई qualified और conditional acceptance हो जाता है, condition modification और variation आ जाता है original offer में. Cross offer क्या होता है? Cross offer is not a mutual acceptance. Okay, इसमें both parties execute identical offers and they are not aware of it. So cross offer does not mean mutual acceptance. Standing offer, which is open for a fixed period of time within which anyone can accept it, like tenders for a given period of time, that is standing and open for all. Okay, so that was it. Okay, apart from that, here is essentials of a valid offer: LCC, ACN, SEDS. So it must be capable of creating legal relations. It must be certain, definite, or not vague. It must be communicated to the offeree. It must be made with a view to obtaining the assent of the party. Now here, it must be communicated to the offeree. Lalban Shukla versus Gauridat, the lost nephew. Okay. Now it must be made with a view to obtaining the assent of the other party. It must be conditional. It may be conditional. Offer should not contain a term, the non-compliance of which would amount to acceptance. The offer may be either specific or general. The offer may be express or implied. Offer is different from a mere statement of intention or invitation to offer. A mere communication of information, a prospectus and advertisement. Under here, IAPI, that is a statement of intention and announcement is there. Okay. And then offer must be distinguished from an answer to a question. Harvey versus Facey, इसमें दो क्वेश्चन पूछा गया था. Will you sell us the bumper hall pen? And then second is Telegraph's लोएस्ट कैश प्राइस. तो जो ये हार्वी पूछा था और फेसी ने जवाब सिर्फ ये सेकंड वाले क्वेश्चन का दिया. इसका मतलब ये नहीं है कि जो फेसी है वो अपना बम्पर हॉल पेन जो है वो बेचने के लिए तैयार हो गया. ओके नाइस. उसके बाद स्टेटमेंट ऑफ प्राइस इज नॉट एन ऑफर. हार्वी फेसी का केस में सेम. एन इन्विटेशन टू ऑफ मेक एन ऑफर इज टू डू बिजनेस. ओके, स्टेटमेंट ऑफ प्राइस इज नॉट एन ऑफर. उसके बाद इन्विटेशन टू ऑफर और ऑफर में क्या डिफरेंस होता है? सो वी कैन से दैट इट इज केपेबल, ऑफर इज डेफिनेट एंड केपेबल ऑफ कन्वर्टिंग एन इंटेंशन इनटू अ कॉन्ट्रैक्ट. वेयर्स जब हम लोग बात करते हैं इन्विटेशन टू ऑफर, तो ये सर्कुलेशन ऑफ ऑफर होता है. ओके, तो इन्विटेशन ऑफ ऑफर प्रेसिडेंट होता है, यानी पहले आता है और उसके बाद आता है ऑफर. सो अब इसमें डिफरेंसेस होंगे. सो लेट अस सी अबाउट द डिफरेंसेस. दैट इज over here the difference between offer and invitation to offer, meaning it is written sequence, it comes after it. Then intention is to bound of an offer is to be bound when accepted, is just to induce to get offers from the public. Impact क्या होता है when accepted becomes a legal and binding contract and legal obligations are there. Okay, start negotiating and no binding contract. Acceptance का होता है when the person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted. A proposal when accepted becomes a promise and cannot be withdrawn or revoked. Okay. The general rule is silence does not amount to acceptance. Mere silence is not acceptance, but unless it is evident from the previous conduct of the offeree, then his silence will amount to implied acceptance. Okay. Now we have some legal rules of a valid acceptance, that is OAC PTMC. Acceptance can be given only by the person to whom offer is made. ओके, दैट इज बोल्टन वर्सेस जॉन्स. जनरल ऑफर कार्लाइल वर्सेस कार्बोलिक स्मोक बॉल. इसमें दो डिफरेंस होता है, एक होता है स्पेशल ऑफर, एक होता है जनरल ऑफर का. तो यू विल सी इट. एक्सेप्टेंस मस्ट बी एब्सोल्यूट एंड अनक्वालिफाइड, लाइक अकॉर्डिंगली इट शुड बी 100%. एक्सेप्टेंस मस्ट बी कम्युनिकेटेड, लाइक ब्रॉकडेन वर्सेस मेट्रोपॉलिटन रेलवे कंपनी. इट इज परसेप्टेबल फॉर्म. एक्सेप्टेंस मस्ट बी इन प्रिस्क्राइब्ड मोड, टाइम. मेयर साइलेंस इज नॉट एक्सेप्टेंस. एक्सेप्टेंस बाय कंडक्ट और इम्प्लाइड एक्सेप्टेंस. बोल्टन वर्सेस जॉन्स के केस में क्या होता है कि जॉन्स जो है वो ब्रॉकल हर्स्ट से वो बात करता है, तो वो उसका क्रेडिटर है, वो उसको समझ करके वो माल का जो है अपने ऑर्डर दे देता है, तो वो जो है बोल्टन उसको सामान भेज देता है. सो दिस इज नॉट डन बिकॉज क्योंकि इन दोनों का कोई आपस में कोई कनेक्शन है नहीं, ये इसको नहीं जानता है और ये क्योंकि सामान अपना जो दुकान है ये अपना इसको बेच चुका है, तो ये कैन नॉट बी क्रेडिट. ओके, सेक्शन 7 क्या कहता है? एक्सेप्टेंस इज वैलिड ओनली व्हेन इट इज एब्सोल्यूट एंड अनक्वालिफाइड, इज एक्सप्रेस्ड इन सम यूजुअल एंड रीजनेबल मैनर. ओके, उसके बाद एक्सेप्टेंस कम्युनिकेट होना जरूरी है. हेवर्थ और नाइट के केस में, ब्रॉकडेन और मेट्रोपॉलिटन रेलवे कंपनी के केस में. एंड वी हैव सम मोर थिंग्स ओवर हियर. कम्युनिकेशन ऑफ ऑफर, कंप्लीशन ऑफ होता है क्या? सेक्शन 4 के अकॉर्डिंग में द कम्युनिकेशन ऑफ ऑफर इज कंप्लीट व्हेन इट कम्स टू द नॉलेज ऑफ द पर्सन टू हुम इट इज मेड. ओके, कम्युनिकेशन ऑफ ऑफर हो सकता है और एक्सेप्टेंस हो सकता है. ऑफर कम्युनिकेशन विल बी कंप्लीट व्हेन इट कम्स टू द नॉलेज ऑफ द पर्सन टू हुम इट इज मेड. सो दिस इज व्हाट इट इज. If no definite date is given, then presume that read and delivered on the same date. But acceptance के case में once the communication of acceptance is complete, it can be repudiated. It can be revoked. Okay, it can be revoked. Okay, against the proposer, that is offerer, against the offerer, or you can say against the proposal or offer and against the acceptor or offeree. When letter of acceptance is put into transmission, that is post पे जाता है, when the acceptance comes into the knowledge of the proposer, यानी कि इसका जो acceptance का knowledge है ये इसके पास चला जाता है और इसके पास letter of acceptance इसका आ जाता है. that is what acceptance, completion होता है communication का. Acceptance over telephone or telex or fax. Okay, the contract is only complete when the acceptance is received by the offeree and is made at the place that the acceptance is received. यानी call drop करेगा, disturb करेगा तो it is not a valid कॉन्ट्रैक्ट. रिवोकेशन के टाइम पे ऑफर या प्रपोजल का रिवोकेशन हो सकता है, एक्सेप्टेंस का हो सकता है. ऑफर कैन बी रिवोक्ड अंटिल इट इज एक्सेप्टेड. एक्सेप्टेंस का रिवोकेशन हो सकता है बिफोर इट कम्स टू द नॉलेज ऑफ द प्रपोजर. उसके बाद यहाँ पर दिया हुआ कम्युनिकेशन ऑफ एक्सेप्टेंस. एक्सेप्टेंस इज कंपल्सरी एक्सेप्ट इन द केस ऑफ जनरल ऑफर, जैसे कि कार्लिल वर्सेस कार्बोलिक स्मोकबॉल. कार्लिल जो है वो जाकर के कार्बोलिक स्मोकबॉल कंपनी को तो बोली नहीं थी कि जो आपका जो वो स्मोक बॉल इसको मैं यूज कर रही हूँ. ओके, सो दिस वाज अ जनरल अग्रीमेंट. एडवर्टाइजमेंट्स आर इन्विटेशन टू ऑफर बट इफ अटैच्ड विथ रिवॉर्ड्स देन जनरल ऑफर. ओके, अब यहाँ पे है मोड्स ऑफ रिवोकेशन ऑफ ऑफर. मोड्स ऑफ रिवोकेशन ऑफ ऑफर है NLNDCNS, दैट इज बाय नोटिस ऑफ रिवोकेशन, लेटर ऑफ ऑफर या फिर लेटर ऑफ रिवोकेशन हो सकता है. बाय लैप्स ऑफ टाइम हो सकता है, बाय नॉन फुलफिलमेंट ऑफ कंडीशन प्रेसिडेंट हो सकता है, बाय डेथ और इंसैनिटी हो सकता है, बाय काउंटर ऑफर हो सकता है, बाय द नॉन एक्सेप्टेंस ऑफ द ऑफर अकॉर्डिंग टू द प्रिस्क्राइब्ड मोड और यूजुअल मोड हो सकता है, बाय सब्सिक्वेंट इलीगलिटी होता है. कम्युनिकेशन ऑफ स्पेशल कंडीशंस में जो है वो टैसिटली होता है. ओके, उसके बाद लिली वाइट वर्सेस मनसोमी, दैट इज 1970. इसके केस में क्या हुआ था कि अगर आपके जो क्लोथ्स है वो अगर खो जाते हैं किसी कारण से तो आपको 15% उसका मार्केट वैल्यू रिटर्न होगा, जो कि नॉट रीजनेबल है. तो इसमें ड्राई क्लीनर जो था वो लायबल था. राइबो ट्रांसपोर्ट कंपनी वर्सेस घनश्याम, इसमें क्या होता है कि घनश्याम और ट्रांसपोर्ट होता है, गुड्स देता है इसको, तो लेटर ऑन लाइबिलिटी इज लिमिटेड. इसको बता दिया कि गुड्स तक ही लायबल है. ओके, उसके बाद दिस वाज द एंड ऑफ द यूनिट 1. ओके, थैंक यू एवरीवन.